Greetings.
Hi, Mr. Howell. We are getting ready to get started. Let me put you on speaker so that we can proceed.
Yes.
On the record is the Jessica Howell and the Steve Howell matter. Counsel, if I could have you state your appearance. Good morning, Your Honor. Rachel Lujan on behalf of Petitioner Jessica Howell, who is present for a non-personal. Ms. Howell, were you sworn in this morning? Yes, ma'am, I was. Mr. Howell, if I could just have, you have not been sworn in, is that correct?
Greetings. No, I haven't been heard. I am Nadi Ta'el, copyright trademark, authorized representative of Asim Najee Ismar Howell, copyright trademark, present.
Mr. Howell, I'm going to have you sworn in.
I affirm that I stand on the truth, that I represent the truth. I affirm.
Mr. Howell, do you solemnly state that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I stand affirmed on the truth.
Thank you. I have several matters on my calendar. I'm just going to take them one at a time. And I'm going to ask you, Mr. Howell, you have filed a request for order regarding modification of custody, as well as seeking a warrant for Jessica Howell's arrest. That was filed on August 3rd, 2021. There is a request for order that was also filed by you, Mr. Howell, to modify child custody, to move to recuse the judge, and to issue a bench warrant. That was filed on August 2nd, 2021. There is a request for order regarding modifying child visitation and seeking a change of venue to the Arizona court that was filed by Jessica Howell. And there was a hearing to modify custody and visitation that was originally filed by Mr. Howell on March 15th, 2021. Those are the matters that I have on calendar today. Ms. Lujan, have you received copies of the request for orders that were filed by Mr. Howell on August 2nd and August 3rd? Yes, Your Honor. And have you filed any response to those? I have not, Your Honor. I was going to virtually attest those. I'm not served. And Mr. Howell, did you receive the request for order to modify child visitation and a request to change the venue in this case?
No.
To Arizona?
I was never served any documents from the attorney. You instructed her or whomever is representing the opposing party, you instructed them to tender me the documents that were emailed. That was your instruction. That was not followed through. Also, this RFO that you're sharing with me, first time I've heard of it, wasn't served.
There was an ex parte hearing, I believe, on that matter, and I do believe, Mr. Howell, you were contacted for that hearing. If you'll just wait one moment, I want to look at the minute order on that. So that was filed on July 30th. Let me just see what this is. On July 30th, I have attorney Marina Lujan present, petitioner Jessica responded, Seam Howell present by telephone. I found no emergency and set the matter for today's date. And Ms. Lujan, you have not served Mr. Howell with your paperwork? They have been served, Your Honor. He has done paperwork. Has responded to our email when we served that paperwork on him.
I can barely hear her response. Was I?
Mr. Howell, Ms. Lujan said that you have received that paperwork.
Do you have a proof? Do you have a proof of service from her? I don't have. I'm just letting you know I have not received that documents. Did she file a proof of service that says when she sent me these documents? I don't have any. I've never been sent any documents.
I'm just telling you, Mr. Howell, what Ms. Lujan said because you said you could not hear.
Oh yeah, I understand. I thank you, much appreciated. My question was, do you have a proof of service from Ms. Lujan who states that she served me documents?
I have her statement that she said you responded to the email correspondence that she sent you. When
So that's hearsay. That's not the answer to the question. You're just doing hearsay. I asked a specific question. Do you have a proof of service? She stated that she served me documents. I stated that she did not. So do you have a proof of service so we don't have to move forward with hearsay?
And Ms. Lujan, did you file a proof of service that you had served Mr. Howell electronically? I don't see in my file a proof of service. However, I know that's important.
Overstood. There's no proof of service. It's null.
Just a moment, sir. Just a moment, Mr. Howell. Speak up, Ms. Lujan. I'm sorry. I don't see a file proof of service in my electronic files, but I know that the courts are impacted with those, so I can't say whether or not have it. Mr. Howell, I do know that I do not have one in my court file. What I am going to do is have my judicial assistant look on our online to see if it has been filed, a proof of service of their request for order, to see if it has been filed, because we are having difficulty getting physical documents into the court files at this time.
Overstood.
So if you'll just wait one moment, we're going to check our
Certainly, but you should also understand the question that you asked Ms. Lujan was if she filed a proof of service. She didn't answer the question. She just said, I don't see one.
Mr. Howell, she just answered it saying she does not have that in her electronic file.
Yes.
But she knows that the courts are impacted, and when they do send proofs of service and ask to have them filed, the court is behind in getting paperwork filed.
I understand what you're saying, but I understand what you're saying. It's a twisting of words. What you're doing is
You cannot interrupt me. You just have to wait until I finish, and I will give you the same courtesy.
I understand.
I'm saying to you that Ms. Lujan's office may have filed electronically a proof of service. She does not have a record of it yet. We may have it in our court file because it has only been scanned, but we may not have anything at all.
I'm overstanding what you're sharing. I'm overstanding.
We're taking down what you're saying because you're talking over me. If we do not have a proof of service that you were served with that paperwork, we are not going to hear her matter at this point.
I understand. Again, her matter is not to be heard. I have other matters that trump her matter. Do you understand? Why are you moving forward with her matter when I have matters since March that have been filed? What you're doing is a twisting of the proceedings, which is obstruction. It's Title 18, Section 1505 is what you're doing right now. You cannot move forward with her case, not even for the fact she didn't serve me. So you can find out that there's no proof of service, and you're not moving forward with her RFO. I have many more accounts that need to be heard before her. You're just going to continue to operate fraudulently? You shouldn't even be hearing the case.
Mr. Howell, I am going to tell you that we have filed July 29th, 2021, a proof of electronic service from Ms. From Brenda@moorefamilylawgroup.com, I electronically served the following documents: request for order, CV and change of venue, and blank responsive declaration to request for order. UCCJEA and blank UCCJEA, declaration renotice of ex parte notice to opposing party, proposed temporary emergency order. This was served on Sue Howell electronically at ASINNAJEEBEY@gmail.com and NADIETAAEL@gmail.com on July 28, 2021. It's dated July 28, 2021 and signed by Brenda Castro.
Are you finished?
I'm going forward. I'm going through another document. Just a moment. Proof of electronic service. File stamp July 30th, 2021. Again, that states from the Moore Family Law Group the same request for order, and says that it was electronically served to you on July 28th, 2021.
Last time, are you done? Can I speak?
Thank you, Mr. Howell. I'm just trying to make sure that everybody has served everybody with their paperwork. You are saying that you have not received this paperwork. Is that correct?
That is correct. And the last time you spoke with Ms. Lujan, you let her know that she needs to send me the documents. That email is not sufficient. You let her know. You spoke to her. She replied, "Yes, Your Honor," to you. So now moving forward, I have not received any of the documents. The proof of service has only been sent by email to your department. That is, again, her doing whatever she's doing to make it seem as if the paper was served on me. But you already let her know how she needs to serve the documents, which they have not been served. And you just reiterated that fact by putting it on the record, for the record, to let the record show that she did not follow your instructions.
And Mr. Howell, the paperwork that you had filed, Ms. Lujan indicates that she had received that. Was that sent to Ms. Lujan electronically?
Why don't you ask her what she has? If she has it and she's agreed that she has the documents, then we need to move forward, correct? If she has documents that she said that she has, then we move forward, regardless of how she has them. You guys have the proof of service.
Did you file a proof of service as well, Mr. Howell?
No, I did not. But did she answer the question that she has the documents? Yes. So there's the evidence to the facts.
I'm not sure what documents she received, Mr. Howell, because I do not have a proof of service from you that shows what documents you sent.
You just asked her. You just asked her the 2 dates. You just asked her the 2 dates. You just asked her the 2 dates, and she responded, yes, she received them from the 2 dates. Go back and ask the court reporter.
What documents she received, Mr. Howell, because you did not file a proof of service to say what documents you emailed her or sent her electronically or through the mail.
You just asked her if she received the documents from those dates, and she responded that she received the documents for the 2 dates that you just shared with her. So now you're asking me.
I do not know what all the documents she received. The documents the court received were numerous and voluminous. I do not know if she received all of your documents. So I'm going to ask Ms. Lujan what she did receive and ask you if that is what you filed. Because I do not have a proof of service from you stating all the documents that you did file and send to Ms. Lujan.
Continue.
So we'll start with the one from August 2nd, which is the request to modify custody and other to move to recuse judge and issue bench warrants. Can you tell me, Ms. Lujan, what documents you received?
Let me look at my email. Oh, she got those. Yep.
I received the request order, change custody, recuse the judge, issue a bench warrant returning Indigenous children. I have the filled out bench warrant attached to it, the declaration. That's about 9 pages with Exhibit A. It has the entire party that filed, I believe, the day before. It's about 145 pages long, so it's got a number of Secretary of State lien amendment acknowledgement, PC finance statement amendment. Did you get these electronically? I did. Was there an indication of what the documents were that were being electronically sent to you? I believe they were sent to the most I'm not sure. Oh, they didn't know. So it's self-side. And do you also then have the documents that look like they were? I have some documents. The court file stamped it August 9th, 2021, which is change, seeking a request for order change of child custody and temporary emergency orders to move to recuse judge and issue Jessica Howell bench warrant returning Indigenous children with many attachments. And then there is one for just a moment. There is the minute order in the court file for August 3rd ex parte that the court found was not an emergency and was set for hearing on today's date. But you're saying that you did receive those, Ms. Lujan? Yes. Mr. Howell, are those the papers that you did send Ms. Lujan for your request for orders?
Yes, those are. My honor, is there a move away order established? You hung up on last time I tried to get that from you. Is there, I already know the fact there is no move away order. So could you let me know? Is there a move away order?
There is a move away order, Mr. Howell.
What was that?
There is a move away order, a relocation order.
There is a lawful move away order? Are you sure?
Yes, there is.
Was there a move away order which established the fact that I was there that allowed them to proceed?
I can tell you that this was done by, I believe, Commissioner Torsha, and there was a relocation order.
No, there was not. I've evidenced the facts.
Mr. Howell, if you'll wait, I'll look through the records. I have several of your volumes here, but I do not have all of them. So let me see if I can find them.
I have all of them sitting right here in front of me. So as you look, I'll look and share the facts. I've already evidenced the facts, so you didn't have to look through them all. I made it simple for all of you.
Mr. Howell, I've received hundreds of pages from you. And it does, again, between those pages, sometimes there is some information about minute orders, but generally it is a legal argument that you've made. So if you wait just one moment, I will look through our registry of actions and find the order. Wait one moment, please. Your Honor, that helps. I believe the order was from June 17th of 24th. Okay, just one moment.
I have the roster, or excuse me, the what do they call this right here?
Registry of action.
The minute orders. Well, I printed the whole. I have the volumes, but I printed the entire the actions which are on the website portal, and you can receive it yourself, and you will see it's succinct, and it shows you that there was never a move away order. The move away order by it's Tyra or Magistrate Riley was an unlawful move away order. Let me finish. She never established a hearing where the two parties were heard. What was established was a fraudulent domestic violence, which was put on calendar at a later date, and then the attorney at the time filed a move away order. And then when we had the hearing date, the magistrate at the time moved forward with the hearing of the move away, granted the move away, and then went to hear the domestic violence account, which the attorney said that they didn't have any information, and dismissed the case. So it was fraudulent. There was never two sides heard. It was an ex parte move away hearing, which is unlawful. And there is actually a ruling to that, which was a case law that I shared with you that was also filed. The rules of procedures for reaching family law decisions contained in the Family Code, the Code of Civil Procedures, the California Rules of Court, and local court rules are not mere suggestions. The rules or procedures are commands which ensure fairness by their enforcement. So there was never a lawful move away order. It's similar to what you are sharing today, as you are trying to hear her move away when there's so many more accounts. So the move away is unlawful, which is voided. It's null, because you can't.
Mr. Howell, I'm going to read you the minute order. This is a request for order that was filed by Jessica N. Howell regarding modifying child custody visitation.
What's the date? Share with us the date.
June 17th, 2014. This is in front of Judge Tara Riley.
Like I said.
Where Jessica Howell was present. Attorney Torrance Howell was present. Respondent Asim Howell was present. The request for order was held. Father completed Solutions for Families Part A years ago. Father is to reattend Solutions for Families Part A. The Family Court Services report was filed. The written report was received from the Child Custody Recommending Counselor J. Hilton. Pursuant to Family Code Section 3048, the court has jurisdiction to make orders regarding custody under the Family Code and the Uniform Child Custody Jurisdiction and Enforcement Act. Notice and opportunity to be heard was given to the parties/responding party as provided by the laws of the state of California. The country of habitual residence of the child or children is the United States of America. The court finds it has jurisdiction to make orders regarding child custody under the Uniform Child Custody Jurisdiction and Enforcement Act. Custody and visitation ordered as follows. Pursuant to the attached recommendation as modified and with additions as
I'm going to object, and I'm receiving the same document in front of me. So I'm going to objection to what you're sharing. What you need to do is move forward to the date, which is May 2nd, 2014. Because what you're doing right now is you're receiving the move away, which was granted, which was unlawful. You're not moving forward to sharing with the court on the record, for the record, that there was already accounts established that needed to be heard by Riley before the move away. So what she did was she decided to, no, listen, you listened, I've listened to you, I gave you the same courtesy that you should be giving me. So let me continue.
Corrected me, and I'm going to finish reading this document into the record, and then I will look at the May document you're asking me to look at.
All right, I will. After you finish on the record, let me go ahead and receive the accounts that were established before what you're sharing, because what you're doing is it's a twisting of words.
I can tell you that the recommendations and as modified the orders were, mother is allowed to move with the minors to Arizona. The minor is not to be brought in public during medical treatment due to immunity issues. If around other minors in the home, those minors are to wear masks. All medical directives to be followed by parents. Parents to have daily telephone contact with the other parent at a time to be arranged by the parents. Telephone contact may be Skype/FaceTime contact. Each party shall keep the other party informed of his or her current address and telephone number, and those of the child or children, and shall notify the other within 24 hours of any change of address or telephone number. If father tests clean, then his first weekend visitation to be the third weekend instead of the second. If father tests dirty, he is to come to court for further orders. Father admits he will test dirty. Matter continued for father to bring proof of prescription and how marijuana used. Holidays and even years, mother to have minors for Easter from 5 p.m. Saturday to 5 p.m. Sunday. In odd years, father to have that time. Whoever has minors for July 4th and Halloween has them. Whoever has minors for 3-day weekends has the third day. In even years, father to have minors for Thanksgiving from Wednesday 5 p.m. to Friday at 5 p.m. and mother to have minors from Friday at 5 p.m. to Sunday 5 p.m. In odd years, the opposite will occur. In even years, mother to have minors for Christmas from noon on Christmas Eve to noon on 12/26. In odd years, father to have that time. Father requests court trial on custody and visitation orders. Father considering whether 7:30 should be ordered. Court to inquire at next hearing. Custody and visitation issues will not be set for court trial on DV court trial date. I'm sorry. Yes.
On DV as in domestic violence?
Just a moment, sir. It says that custody and visitation issues will not be set for court trial on DV court trial date. Hearing regarding letter regarding marijuana prescription set for June 25th, 2014 at 8:30 in Department S48. Set on trial readiness/assignment calendar for September 5th, 2014 at 8:30 in Department S48. First tentative date for trial is September 15th, 2014.
Do you understand what you just received about the DV?
It says that the court is custody and visitation issues will not be set for court trial on DV court trial date.
Okay, awesome. So when you're finished, let me know so I can continue.
Okay, the like the DV court trial date. On May 2nd, 2014, there was an ex parte. You were not present, Mr. Howell. Ex parte hearing was held. Declaration regarding ex parte notice was filed. Jessica Howell was sworn and examined. Court notes notice of hearing has not been given. The hearing was continued at the request of petitioner, and the current hearing was continued to May 5th, 2014 at 8:15 in Department S11X. And I'm not sure, I'll look at the next minute order for May 5th.
All right. Can I continue and share so I can share with you the tactic that was just utilized? Because there.
Just a moment. I'll get you the May 5th.
Just make sure you give me the opportunity so I can share you the tactic that was used.
Mr. Howell, the May 5th minute order states that petitioner Jessica Howell was present. You were not present. There was a declaration regarding ex parte notice filed. The ex parte hearing was held. The ex parte orders were granted for Jessica Howell, and the clerk's office set this matter on calendar on May 27th.
Can you, for the record, so that way everybody can hear and the court reporter can type it up, what were those orders granted for, which I didn't show up, which was a domestic violence, temporary restraining order for domestic violence, correct?
Yes.
Correct. So that was March 5th. May I continue?
That was actually May 5th.
May 5th. That was May 5th. Strike March, correction, May 5th.
The matter was then put over for a notice hearing for May 27th, 2014.
So let's not skip too far ahead. All right? So we're sticking with May. So May, there was a domestic violence, which she said there was a DV. She filed an ex parte same day hearing. Didn't give me a proof of service. That's a tactic. She went there. They denied it. Then on the 5th, excuse me, the original date that she filed the ex parte was that the hearing on the 2nd, or was that the first? Substitution of attorney. Substitution of attorney, May 5th by Jessica. All right, Howell. May 2nd, she files a domestic violence. So she gets an attorney, has the attorney say that she's been violated, then goes to court without serving me. They kick it out. Then we go back to court May 5th, grant the temporary restraining order. Then her attorney files a move away, right? So files the move away, which the magistrate at the time hears first. Doesn't hear the domestic violence, doesn't give me an opportunity to speak. I am not allowed to see the children for this time. And then when we go to the hearing, the magistrate does not hear the account of the DV first and hears the move away, grants the move away, and then the attorney dismisses the domestic violence. That is a tactic. That is an unlawful move away, and that is an obstruction of proceedings. You do not have one account and then file another one and then allow the ex parte account to be heard first. Do you understand what I'm saying? That's simple, and it's succinct, and it's right in order. And what you've done is a twisting of words. And similar, I'm not finished, and similar to what I just shared with you right now is what you tried to attempt in the beginning of this hearing, asking if there was proof of service for a change of venue, trying to hear the change of venue when there's several other accounts that need to be heard. You are doing the exact same twisting that the magistrate did before. So now with this on the record, for the record, let the record show that you have been continuously moving forward fraudulently. Do you have an honest bone in your body?
Forward on any case at this point in time. I was merely asking if everybody had been served with their paperwork.
You also said that there was a move away order that was valid, and I just evidenced the facts that it wasn't valid. So I evidenced the facts that the move away order wasn't.
It's to you that I asked if you had been served, and you said no. I asked for a proof of service, and the only one I had was electronic service. You said that's not sufficient because Lujan was ordered to provide you hard copies through the mail and address or through some other form of service, not through electronic service. I haven't even reached any other issue on that request for order by the petitioner. I will indicate to you that on May 16th, 2014, there was a request filed, or a request for order was filed to modify child custody visitation seeking a move away. And on that date, you were present, Ms. Howell was present, and Torrance Howell was present as a petitioner's counsel. The request for order was held. Respondents request continuance to retain counsel on this issue and the DV hearing set for May 27th. The 5/27/14 hearing was advanced and continued to June 17th, 2014. All temporary orders remained in full force and effect until that date. You were referred to Family Court Services for the next available appointment to talk to the child custody counselor. The hearing that was scheduled for May 27th, 2014 was vacated. The hearing on domestic violence by Jessica Howell was set for June 17th at 8:30 in the morning. The current hearing for the request to modify custody visitation and relocation was continued to the same date, June 17th, 2014, at 8:30 in the morning. I've already read you the request for order that was held on June 17th, 2014. And if I can have you wait just one moment, I will find the minute order for the domestic violence, which is the same date, June 17th, 2014.
So what you're sharing.
Excuse me, Mr. Howell. You're stating that the court heard the custody issue before they heard the domestic violence. So I just want to see if it was heard on the same date or not. The minute order that I have also shows June 17th, 2014, in Department S48. The appearances were the same. Jessica Howell was present, Torrance Howell was present as her attorney, and you were present. The request for order was held. The court gives tentative decision of 3-year restraining order with 52-week batterers program and parenting class. The matter is contested. A court trial was requested. All existing temporary orders shall remain in full force and effect until July 18th, 2014. And the court trial on the domestic violence with children that was filed May 2nd, 2014 was set for trial on July 18th, 2014. And on July 18th, 2014, do you have that minute order before you, Mr. Howell?
I do. But check this out. The hearing was heard on June 17th. The hearing for the domestic violence hearing, read domestic violence by Jessica Howell, Tara Riley. That was on the 17th. The hearing for the move away was heard, you guys put it on the record, the 14th. So there's your evidence that there was a twisting of the accounts. The move away is not valid. You would need to have both parties sit with a mediator establishing, well, first there would have to be the facts established that she wants to move away, and then the mediator would be meeting with us to establish, what is going on. That never occurred. That was never granted. That was never allowed. So there was a move away order. Hold on and let me finish. There was a move away order granted before the domestic violence, but the domestic violence was filed before the move away. So there is a twisting of the accounts so that way the opposing party could get away scot-free. And you've assisted that. So that contract is voided ab initio from the beginning because it's not proper procedures.
You've made your record and let me make mine. July 18th, 2014, the matter did come back before Judge Riley concerning the domestic violence, and on motion of the moving party, a dismissal was requested, and that dismissal was granted.
Awesome. That's giving more evidence of the facts of what I just shared with you. That you just proved you just evidenced the facts that the domestic violence was not heard properly. You just stated that in July of 18th that it was dismissed. It's also on the record too for June 17th. But the move away order was granted, as you said, June 14th. But the DV was filed on May 2nd. You understand what I'm saying? So you just evidenced the facts that it's a fraudulent order.
Mr. Howell, the move away was granted on June 17th, 2014, just to make the record clear.
Okay, so if that's what you said, then
Also, sir, it was set tentatively for trial. The relocation was allowed. It was set tentatively for trial on September 15th, 2014. So let me see if you had a trial on that issue. And you were referred to family court services, and you had spoken with the child custody record.
Objection, not for a move away. It's sitting right here in front of your face. It's not for a move away. There was a DV that was filed on May 2nd, after there was a substitution of attorney, which was May 1st, 2014. So May 1st, 2014, substitution of attorney. The second day, that attorney filed the domestic violence, not a move away. The move away order was heard before the domestic violence. That's not proper procedures. That's obstruction of the proceedings. So that account is fraud. So it's void ab initio from the beginning. You can go ahead and go back and forth, but the facts are right there in front of you. The first was the 5th, May. She received an attorney. You have that. The second was a domestic violence, not a move away. So stick to the scripts.
Mr. Howell, on September 5th, there was a...
Objection. There was a domestic violence filed on the 5th, not a move away. So stick to the accounts that are in front of you.
No, there was Mr. Howell, I'm just making my record again. On September 5th...
No, you're twisting the words up. You're doing what fraudulent judges do. So stick to the script. There was the 5th. May 1st, there was a substitution of attorney. May 2nd, that attorney filed a domestic violence order, not a move away order. Overstand?
Mr. Howell, did you appear on September 5th, 2014 for the...
I see what you're doing. Are you going to move forward, or are you just going to continue to just tacit consent agreement? The 5th.
I'm going to move forward, Mr. Howell, because Mr. Howell, Ms. Lujan has indicated she's received your paperwork. So I'm ready to move forward on your paperwork.
Well, then let's move forward. There was not a move away order, and the children should be here with me. So return them and dismiss this case. Return the indigenous children because they are not chattel property. Your corporation is soon to be dissolved. It's registered in Scotland. This venue is improper. It would be in England if you were to, you are an agent of the UK. These are all facts. And you're not going to object to it because it's the facts. It's already been established in hearings before. My children have been kidnapped. You're assisting with the hostage taking and the abduction. You and the agents have conspired to do so and have not returned my children. And your other corporations are attempting to extort money out of the Ses Tuike Vi, which should be dissolved, which Hugh Bruce Watts and the solicitor have already been tendered documents informed of this issue. It's only a matter of time till it comes down the line, till it gets to you, and I'm sure you're the fall girl guy as it is, because you're not moving forward honorably. I just shared with you the facts that the substitution of attorney was May 5th. There was a domestic violence filed on the 2nd. There was no move away order filed until another week later. But yet the move away order was heard first, and then the domestic violence was dismissed. But yet you want to try to go into September and so on and so forth. But you're not wanting to deal with the accounts that I'm sharing with you that are right in front of you. A twisting of words is not honorable of a judge. And that's a maximum law. I'm sure I'm not stating it correctly. So what needs to be done at this hearing is the children need to be returned immediately. I'm not looking to incarcerate their mother. I'm looking to be able to have a communication with her outside of you, oppressor, who is fraudulent. You're not a judge. You're an employee of the United States Corporation, Title 28, United States Code 3002, 15A, which is a federal corporation and not a government. My children are not chattel property. They're not human cargo, which you are trafficking in human cargo. Are you willing and ready to release my children? That's the question today.
Have you completed your statement, Mr. Hull?
It's not a statement. Those were facts that I just evidenced to you. Information may be hard for you to understand.
Have you completed your factual statements, Mr. Hull?
For now.
Ms. Newman, what is your response as far as Mr. Howell's request to, I do not know if Mr. Howell actually is seeking a bench warrant any further against Ms. Jessica Howell, but I can have you respond to that.
I don't believe that Mr. Howell has laid any proper facts or evidence before the court for a bench warrant. The kids were properly removed from the state. There is absolutely no reason to issue a bench warrant.
And it would be, in fact, his remedy with respect to the 2014 order and how he didn't file a right and he didn't appeal the order. So trying to bring it before the court at this point is.
Objection. No fact shall be tried in a courtroom. No fact and no law should be tried in a courtroom. I've given you facts. I've evidenced the facts. What she shared was a belief, and she even said it on the record, for the record, let the record show. She stated her belief. I've evidenced the facts. The facts are there. The bench warrant has been issued.
It has not been issued.
No, the bench warrant has been filed. Excuse me. So let me correct myself. The bench warrant has been filed. She did not have a proper move-away order. She was assisted with the attorney. She used some tactic, and the courts or the corporation has assisted in this kidnapping and genocide. These are facts. So her belief system, that's just what she does. And the fact is, her corporation are debtors, and she's an absconding debtor also. On the record, for the record, let the record show. These are not honorable entities, agents that we're dealing with. I've shared with you the facts. So moving forward, again, the children need to be removed from where they are to return to their father so they can continue their indigenous lifestyle.
Mr. Hunt, did you have anything further on the request to return the children?
I do want to make a note that Mr. Howell has filed this request previously, and his motion on July 31st, 2018 for the return of indigenous children was denied with prejudice. I don't believe he can bring up before the court again. These children are not indigenous and come back with the same motions over and over.
Objection. Again, the facts have been evidenced. What you're doing is backpedaling.
Mr. Howell, at this point, the court is ready to rule on your request for a bench warrant to be issued against Jessica Howell. The court denies that request. There was a valid relocation order that was made. Ms. Howell was allowed to take the children to Arizona.
I just gave you the facts. Objection.
Mr. Howell, I'm making my ruling.
Overstood.
To take the children back here to California and to place in your custody is denied. The request that you have made to recuse the court and this bench officer is denied.
Yeah, that's a little backwards, don't you think?
I'm just responding to your motion, sir.
Overstood, but you would first say that you wouldn't recuse so you could move forward with the hearing. So basically, you don't even know what you're doing. You're not even hearing this account properly, which is
Well, Mr. Howell, I have indicated
Abdul Kul Shayuat Biwa Samus Patimta. I asked the ancestors to intervene and pay you a visit because this needs to be corrected.
I apologize, Mr. Howell. Could you repeat that because I did not have the microphone close to the speaker?
I'm going to make a request to the ancestors, to the IGC, to the Confederation, to pay you a visit because what you're doing is unlawful, right? There's other energies and entities that have contractual obligations. You have contractual obligations also, but you serve, as I see, disagreeableness. You are a disagreeable entity. I've evidenced you facts. I've shared with you. But moving forward, you are fraudulent. There's no fairness. You don't even follow your own rules. You don't honor the rules of engagement. You don't honor the rules of procedures. You obstruct the law. You are ruling out of your personal capacity and not through judicial capacity. So I see that you are the fall girl, and it's unfortunate for you. So as I share with you, I look to the ancestors now as I move forward in this realm, in this physical realm, using the knowledge obtained and honoring the contracts. That's what I do. I honor contracts. But as I see your disagreeable nature, so I have to speak to a higher plane. So that's what I'm sharing with you, and I'm letting you know. You have a contract, right? You abide by God. You swear people in. You have a Bible, right? Except for you don't abide by any of those. None of those. The children, a marriage between a man and a woman, the children follow the father. These are maxims of law, but you choose to negate that, but yet you say you honor your oath, which is a spiritual oath. You don't even honor the spiritual realm. You don't honor etheric realm. You don't honor the physical realm nor the etheric realm. So that's something that you're going to have to live with or exist with, which is as is you. You understand what I'm saying? Because the facts of the matter is the children are kidnapped, and I haven't seen them. I filed back in February, March, to see the children for visitation, and you have not even allowed that. You stated that your position is the children's best interest. You've proven that to be not the truth. The attorneys have proven that not to be the truth. Even the mother has proven that not to be the truth. 3, almost 4 years, the children are now being alienated from their father. Their development is what is crucial. Not me. I can make many, many more children and have more children. But what is necessary for those beautiful deities, because they are deities, those deities you guys want a piece of, and you want to use them like batteries. I see that. They're either your food or your fuel. And it's very unfortunate because we are in the age of Aquarius, which is the age of knowing, and those who believe and disagree are obsolete and will not be rejuvenated. So, and all of those sets and those minds, I appreciate you allowing me to speak because I am recording this, and this will be shared, and I will be sending this to Hugh Bruce Watts, the solicitor, the duchy, so that way it will trickle down and find its way to you. And as I ask the Anunnaki to pay Hugh Bruce Watts a visit in agreeableness to share the pure care and consideration that we have for all of humanity. Abud Gador.
Mr. Powell, you are not permitted to record any proceedings in court.
I am that I am.
Additionally, I have let you make your record. I do find that there was a valid relocation order made. Your time to either seek reconsideration of that order or to appeal that order has passed.
I never received it.
There is no valid reason for a bench warrant to issue against Ms. Jessica Howell, and the court will not issue that order.
You will be getting a bench warrant soon enough.
The court shall not return the children to you, Mr. Howell, because it is not in their best interest at this time. I did have this set for a review hearing because I had made prior orders for you to have parenting time with the children supervised, either here in California, 1 time per month, and 1 time per month in Arizona. I have not heard from you or Mrs. Howell whether or not you have seen the children. But based on your statements today, I believe you have not seen the children under that supervised program that we have in California, or under utilizing a paid professional supervisor in Arizona. Am I correct in the fact that you have not seen the children since I made that order, sir?
Correct. The children have not seen their father. I have not seen the children. They have not seen any of their family over here. That is correct. And during the mediation, anyhow, go ahead, continue.
Did you go to Arizona to see the children?
Why would you ask me that when I'm here on this hearing today?
I'm just asking if you have gone to see the children in Arizona and have not been obliged to see them.
How would that occur? How would that even happen? How would that even be a possibility when the person on the line is keeping the children from their father? How is that even you know what I mean? How is that even a possibility? I don't even know why you would even ask that question. It's silly.
Have you made arrangements for the children to come to the grant program? Have you made arrangements for a date and time to see the children at the grant program here in California?
Your representatives over there have denied the grant program. I have an email from them saying that, oh, it's some bull, some BS that they emailed me.
I have not been provided with that information, Mr. Howell.
Well, it's published online. It's on YouTube.
Do I? Not that email to me, Mr. Howell. Do you have that email before you?
I have that email. I could forward it to you. You could also go on to, I have 3 YouTube accounts that you could see. I have a personal page, which is called powerofpublication.com. All of that information is on there. Yes. Everything that we do is published. All of our accounts are published online.
Can you tell me just one moment. Ms. Lujan, are you aware that the grant program in California was not provided for Mr. Howell? The information that I have is that on June 25th, my client was instructed to contact Family Court Services to discuss the supervised visits through the grant program. She did so. She spoke to Paula. Paula took a message for the supervisor. On June 30th, Deborah Bowser, the supervisor, contacted her in the morning, asked for her availability and for dates and times that she was available, and said she would contact the agency to discuss availability and get back to her, and she never heard back from them. I don't believe she's received the email that Mr. Howell has indicated he's received, and so that's the only information I have is that my client did contact them in an attempt to get that started. Mr. Howell, if you could, do you have that email before you?
Not in front of me.
Can you bring it up on, and do you have a ability, do you have a computer or an iPad or something that you could bring that up?
Yes, give me 2 seconds.
And it may be dated somewhere in June, maybe toward the end of June of 2021.
Say June what?
Might be from Deborah Bowser. Or it may say something like Family Court Services.
Grant program. The court grant program for supervised visitation is not appropriate resource for you. That's what they gave me. That's what it said. It has been determined that the court grant program for supervised visitation is not an appropriate resource for your matter. You will need to refile to get the matter back before the court to address others. Yeah, so they running that, running that scam, running that fraud again.
If I give you a can I give you a fax number that I would like you to, could you fax that email through this number?
I'm ready when you are.
Area code 909 521 3304.
Got it. I've also emailed Joe Navarro 3 different times, and he never responded. I didn't add him to the lien. I didn't amend it, but now I'm speaking to you. I will go ahead and amend the lien and put him there. I also didn't touch any of your personal accounts, like the gold and the silver and your communications account, but being that you're fraudulent, now I'm going to go ahead and just take those over and give them to my children and go ahead and file all these documents and send it to the CEOs of their company too, so you can go ahead and deal with that on your own also. You're welcome.
Mr. Howell, was that email from Mr. Navarro?
No, that wasn't from Mr. Navarro.
Did it have an email address on it?
Let me double back and see. Where was it? Oh, there we go. That was from okay, it says the email address is fcs@sbcourt.org. So it's not from a in particular individual, it's just from that branch.
What date was that sent to you, sir?
July 16th.
2021?
That is correct.
Let me, if you will permit me, I'm going to take a brief recess and see if I cannot contact Family Court Services to see what the reason was for that email.
I'm sorry, you said July
16th, 2021?
Correct.
If you'll just, we'll be in recess
For about 10 minutes, all right? Mr. Howell, would you prefer that we call you back?
However, I could stay. I could wait. You can call back. I could wait right here. Are you going to call both of us back, or do we just sit here?
I can put Mrs. Howell. I can put her on hold with court call.
All right. Before we go to a recess, or before you call me back, what have we established here today as far as the accounts that I brought to you, and you denied every single account that I brought to you, and now you're sharing with me earlier that the first thing that you were actually sharing was so important to you was the move away or change of venue from Miss Howell. So
that one I am denying it without prejudice. It hasn't been served on you properly, so they'll have to refile and serve it.
Can we get a continuous on that?
Well, I can continue it, but I'm not going to go forward with it now, Mr. Howell, because you haven't been properly served, and you have an opportunity to file a response to it. Since you haven't been served, you haven't filed a response.
So I'm not going to
entertain that today. I can grant a continuance and have you properly served with it so that you have an adequate time to respond to it, and I can put it over to another date, but I am not granting their request at this time because you've not been notified.
Overstood.
Okay. Just one moment, and then
We are going to call you back because the telephone that we are using is line into my department, and there are other calls that have been coming through. So we will call you back when probably within 10 minutes.
Overstood.
thank you.
Greetings.
Hi, Mr. Howell. This is Juliet with Department 46. We're ready to begin.
I'm Nadi Ta'el, copyright trademark, authorized representative of Asim Najiz Moore Howell, copyright trademark, present.
We're back on the record in the Howell matter. Both parties are present via telephone and court call, and Ms. Lujan is present in court. Mr. Howell and Ms. Howell, I had an opportunity to contact Family Court Services, and it appears that Mr. Howell, you are not eligible for the services. They have certain restrictions on the actual grant program. One of the restrictions is that the supervised visit cannot be recorded. And since you indicated that you record everything, that it is not a program that can be provided to you because you would seek to record it.
Is that a law or is that some policy? Where would I find that fact? Because that's just, that's like a policy. There's a sorry.
You might have to contact Family Court Services.
Well, there's a California Penal Code which states that's.
Mr. Howell, court proceedings are not permitted to be recorded.
That's a policy. That's not the truth. That's a person. That's not. That's the.
You, Mr. Howell, that court proceedings are not recorded.
Where's that?
Recorded.
Recite the law.
You have informed me that you are recording.
State the law. Recite the law.
Mr. Howell, we have an official transcript. We have an official court reporter. She is taking everything down.
I understand and I'm listening to you. But when you're stating that there's these laws, you cannot just say we have laws. You have to back them up in accord with what they are. Like when I say the United States is a corporation, and then I tell you the title, 28 United States Code, such and such. Like recording, California Penal Code 50 set allows me to record. Right? Do you know that penal code? Because you're presumed to know the law, but yet you're telling me these personal beliefs that you have without any statute, no ordinance, no codes, no mandates, none of that. You're just saying what you feel on the record, for the record, and let the record show. If you want to establish some type of law or some type of rule, please begin your sentence by saying this is the rule and in accord with such and such, not just hearsay. We are both studying.
Mr. Howell, please listen. The general order of the presiding judge regarding photography, filming, recording, and broadcasting. The purpose of this general order is to protect all persons with businesses in the Superior Court of California, County of San Bernardino, courthouses and court facilities, ensure safe, secure, and orderly conduct of hearings, trials, and other court proceedings, and facilitate the safe, secure, and efficient handling of court business. This general order is made pursuant to California Rules of Court, Rule 10.603, which vests in the presiding judge the authority to establish court policies, and Rule 1.150, which governs media coverage within the courtroom. Wherefore, it is ordered. Number 1, definitions. A, for the purpose of this general order, the term court refers to the Superior Court of California, County of San Bernardino. B, media or media agency and media coverage are defined pursuant to California Rules of Court, Rule 1.150. Number 1, media and media agency shall mean any person or organization engaging in news coverage or reporting, and including any newspaper, radio, or television station, or network, news service, magazine, trade paper, in-house publication, professional journal, or other news reporting or news gathering agency. Number 2, media coverage.
I have it. Hold on. You don't need to receive. Do you have to receive that whole thing?
I'm going to read it all to you, sir, because this is the general order.
I understand. Hold on. Before you move forward, because I have it. It was given to me. And what you're sharing with me is a general order, but that presiding judge who took an oath to uphold the Constitution can't trump the California Constitution, which is Article 1, the Declaration of Rights, and Section 9, a bill of attainder, ex post facto law, or law impairing the obligation of contracts may not be passed. That trumps what you're sharing, which is an order from the presiding judge. This is the Constitution, the California Constitution, which that judge took an oath to uphold. And that Constitution trumps his orders. So his personal policy, not to mention that judge is a de facto magistrate who is an absconding debtor who I have a lien on personally. So, as I stated, California Constitution, Article 1, Declaration of Rights, Section 9, a bill of attainder, ex post facto law, or law impairing the obligation of a contract may not be passed. So what you're sharing with me is treason. Basically, you're sharing with me a treasonous order which is not in correlation with the laws or the guidance of the Constitution, in which that presiding judge took an oath to uphold, but decided to make his own policies while he's inside of that building. So I hope you understand what I'm sharing with you, because that is the fact.
I understand your position.
No, it's not my position. This is the California Constitution. It's not my position. See, you're twisting the words again. What I just shared with you is the facts, but you just said it was my position. When I share with you the facts, sometimes you start to speak and say it's a belief. Well, these are your rules and these are your laws. This is in accord with the California Constitution. So,
and this rule in this courthouse is in accord.
We're not in a courthouse. These are the California constitutions. You said that you're in a courthouse. That is fine. You were sharing with me why we couldn't move forward with the grant. Now you're talking about our hearing right now, which you had no issue with prior to right this second. You see what I'm saying? You are a twisting of the words.
Cannot record these proceedings, and you continue to violate
California Constitution, Article 1, Declaration of Rights. I've just stated to you the facts. Do you want to break the Constitution? I mean, you've already have. You know what I mean?
I indicate to you, sir, that those are the orders.
This is the. Are you higher than the California Constitution?
Mr. Howell,
Are you higher than? Is your authority superior than the oath that you took?
Mr. Howell,
Is your superior? Are you superior than the oath that you took?
I'm not engaging with you, sir.
Do you see what I'm saying? You're not even honorable. Are you superior than the authority which you look? You can't be. You can't have.
Our facility is the one that provides the grant program. The grant program does not permit you.
So you're more powerful than the authority which you derive your power? You have more power than the authority of which you derive your power?
Visitation. At this point in time, on the review of visitation, I'm making a finding that the parties have not been able to have supervised visitation for Mr. Howell. The grant program is not available for Mr. Howell. The court's orders are that these visits in California and in Arizona must be supervised by a professional monitor. I will order that for visits in Arizona, Mrs. Howell is to find a professional monitor who will supervise the visits. She is then to provide that information to Mr. Howell so that he has the name and contact information for the supervised visit monitor in Arizona. They can then coordinate to determine when and where the visits will occur in Arizona. I will have Mrs. Howell pay for the supervised monitor in Arizona. In California, for the visit, you will, Mr. Howell, I will order that you find a paid professional supervisor off of the court-approved supervisor list, and you will provide that information to Mrs. Howell so that Mrs. Howell can coordinate a time where she can bring the children to California for your supervised monitored visit.
When is this going to occur?
Responsible for the payment of that supervised visit.
I'm responsible for the payment of that visit?
For the one in California,
Overstood.
she's responsible for the payment in Arizona.
Okay, so for the one here in California, why don't you just pay for that one? You personally.
I made my order, Mr. Howell.
No, I'm asking you a question. Would you pay for that one personally?
No, Mr. Howell, I am not involved in this case personally.
You're not. You're not. Wait a minute. You just said you just committed. You just lied. You just purged yourself. That's perjury. You're not. You have a. That's perjury.
I am making my orders now. I'll set this for review and also put over the matter that Ms. Lujan filed on behalf of Mrs. Howell in order to have you personally served either by mail to your mailing address in sufficient amount of time for you to be able to file an answer to it. I will have that hearing set for, and I can do it in November. I will order that Ms. Lujan's office mail you the request for order no later than September 24th to 2021. Your response will be due to the court with a proof of service that you have mailed it or emailed it to Ms. Lujan by October 15th, 2021. I will set this for a hearing for either October 28th or 29th or November 5th. I do not know if a Thursday, a Friday, or a Friday is a better day of the week for any of you.
Thursday.
Thursday, I have October 28th, and I also have November 4th.
28th of October. Thank you.
Okay, Ms. Lujan is checking her calendar. Just one moment.
I cannot do the 28th on Internet.
Ms. Lujan is unavailable on the 28th. Would you prefer still to have it on a Thursday, Mr. Howell?
Yes,
Okay, I have November 4th.
that'll work.
Would that be at 8:30?
Yes.
Can we do it at 10:30?
I have a trial starting at 10 o'clock, Mr.
Do you know what time it is right now? And we always end up staying that it's at 8:30. You know what I mean? So it's like, it's ridiculous. So why don't we do it at a proper time? Because it's not going to start at 8:30.
At 11, so if I don't get heard at 8:30 here, I'm not going to be able to make my MSC that day.
I will set it for 8:30 in the morning, Mr. Howell. Ms. Lujan is available, but only until about 9 or 9:30. She needs to get to Riverside for another hearing by 11. So if I set it for 8:30, I will take you as one of the first matters. So we'll do that November 4th at 8:30 in this department.
All right. So the 8:30, just to recap that date, we are going to be heard for what exactly on this date specifically?
The review of the supervised visit and the visitation
And my request.
and Ms. Lujan's request for change of venue and change in the visitation order.
I don't even have visitation. What are you talking about?
Again, those are the ones that are set, sir.
And
Oh.
Your Honor, may I get word on the issue of my client paying for supervised visits?
Not at this time. I'm going to order that she pay for the visits in Arizona and
Nadi Ta'el. Nadi Ta'el. Copyright trademark. That's who I am.
Thank you, sir.
You're welcome.
We'll have you back here then on November 4th at 8:30 in the morning. Mr. Howell, we will again contact you by telephone.
All right. At 8:30, November 4th.
Correct. Do you need any further notice of that date, sir?
No, I don't need any further notice of that date.
Ms. Lujan is notified. Notified, Your Honor. Thank you.